Good morning, Ram. Hope you're well. Welcome to Law for Non-Lawyers, Introduction to the Common Law, Contract Law. Today we're going to explore the wonderful world of contracts, also known as the law of obligations, and we're going to understand why we have contracts, what's the rationale, and hopefully we can identify when a contract's been legally entered into or formed, an enforceable contract, that's important. And also understand some implied terms that over time the law has established through statute to create a floor, if you like, on some minimal facets of a contract. So essentially a contract is a legally binding agreement with words or in writing between two or more parties and private parties. Okay, so we've talked before about public law and private law. Contract law is an area of private law governing the relations between two private citizens. Now that might be individuals as people, but also companies, corporations. Whereas if we've got one party is the state, the government, such as in administrative law, when you're looking at a decision of a government department, or the criminal law, where one party is the state, then that's public law. But contract law is an area of private law governing relations between private citizens. So it's a set of legally binding promises made by one party to another. The law says that they are enforceable, and if one party breaches that promise, then they'll be entitled to a legal remedy to compensate them for any loss. So let's zoom out and think about why the common law has an interest in enforcing agreements. So the starting place is about freedom of contract, and there's a doctrine called freedom of contract, in that we want citizens or individuals to be able to contract whenever they like, and bar some exceptions of illegal contracts. Mostly, the law is not interested in the quality of the bargain. It just wants to enforce the bargain itself or the agreement. So it's based on mutual obligations. And I suppose the law of contract, again, if we zoom out and think about what's the law trying to achieve, well, we've talked about, at a big level, it's about keeping the peace. A legal system is designed to provide certainty, but also to keep the peace, to stop people taking matters into their own hands. So if you entered into an obligation or a contract or an agreement and you had no faith that the other party would do their side of the bargain, things would fall down quite quickly. The wheels of commerce would grind to a halt. You couldn't buy or sell with any degree of confidence. And of course, the state has an interest in tax revenue and in everyone's economic prosperity, in keeping those wheels of commerce going. So the common law of contract, or the law of obligations, is very old and has been going back in numerous forms since trade itself became a thing. Think reciprocity, the mutual obligation that an agreement creates. So it's also known as the law of promises, and we'll find out that you can't be bound unless you've put some consideration into the promise. So we want a system, the law wants a system whereby agreements, not the quality of the bargain or the quality of the agreement, you can agree to buy a Rolls Royce or sell your Rolls Royce for £1. The law's not interested in the quality of the bargain, but what it is interested in is ensuring that any obligation that's been mutually made, and we'll see there are some rules around undue influence or misrepresentation, but in principle, mutual agreement should be enforceable. Okay, so it's a voluntary assumption of legal obligations between two individuals, And it's a means also of simplifying those commercial transactions by ensuring certainty, which is one of the law's fundamental goals, is to provide structure and certainty, but also clarity. But it's also a way of setting out mutual relationship agreement based on promises and action. A famous author once said, the power conferred on individuals to mould their legal relations with others by a contract is one of the great contributions to social life. Some contracts are not obvious, such as entering into a contract of marriage. So you can understand traditionally, and certainly with the landed gentry, contracts were a mechanism to keep land in the family. So a huge effect on social life, but also, as I said, on the wheels of commerce, on a nation's industrial progression. So, as we've said, it's private body of law, operates between individuals or companies, because they're legal entities, who owe obligations created by valid contracts to other individuals or companies. And then, so freedom of contract talks about it's up to the parties to negotiate the terms. Courts are not interested. Well, what the courts are called to do is interpret and enforce the terms of contracts that those parties have agreed to enter into, because you don't have to agree. So the idea is, well, if you've entered into that obligation, then we're just going to enforce that. So in most jurisdictions around the world, it's a mix of common law, because this has been going on for hundreds of years. There are certain customs that have been laid down and rules around the structure of a contract and the form of a contract and its interpretation and what's in and what's out, as we'll see. But also increasingly statutory regulation. So what legislatures around the world have done, and they've come in and set a floor of minimum standards on commercial contracts, sale of goods and provision of services, for example, so that we as citizens all have certainty. And that's because of the unequal bargaining power that's happened over the years with the rise of mass corporations, which now offer essentially unilateral contracts on a take-it-or-leave-it basis. And you have no real power to negotiate. Think about a software licensing agreement, and there's an I agree button. Take it or leave it. You can't haggle. It's not a marketplace in a traditional sense anymore. In that example, you can on a used car purchase. Of course, you can go and haggle and make an offer and a counter offer, but on certain things, prices are fixed, and that's not an equal playing field. That's not a level playing field. And I think the I agree is a great example of, well, if you don't agree, well, then you're not doing business with that corporation. So it's not a level playing field. And in order for citizens to be made more level, governments intervene with statutory provisions that insert terms into any contract that individual parties are not able to vary. So think about reasonable fitness for purpose is a classic one in the sale of goods, and that is, and most countries have this term, that the goods being sold in the marketplace by a retailer are reasonably fit for the purpose for which they're sold. Another one is that and that may be for a duration of, say, 12 months. So if you buy a calculator, it should work as a calculator and it should not break in the first 12 months. And that would be a statutory guarantee, if you like, on that term. And the calculator seller can't vary that and say, oh, well, ours is only 6 months. So there are statutory guarantees that have been legislated, and you can almost judge a country's legal maturity or economic sophistication by the quality of its statutory regimes around sale of goods. So I think some countries where there's lots of counterfeit goods, you probably find that their statutory guarantees are much lower, whereas developed nations, certainly in the UK, Australia, North America, huge rafts of statutory guarantees that have inserted clauses into contracts so that we as individuals don't have to haggle and insert those. And it does set a floor on a minimum standard of quality, essentially, in the marketplace. Now, obviously, some of those, or a lot of those, would be void or not enforceable or applicable in a second-hand situation. So if you sold something through, as an individual citizen, through the trading post or the local paper, then those statutory guarantees don't apply. So they're really reserved for retail situations in the world of commerce. Okay, so the role of courts is to interpret and enforce those terms of contract that you as a party have individually agreed to. In most, so we've got common law and we've got statute. So it's a blend of laws. As I said earlier, also known as the law of obligations. So there are a number of key steps that need to be taken in order for a contract to be valid and legally binding, and we call these formation of contracts. And there are some classic steps to be made. So the first one is an agreement, and that's because what we're looking for is the intention of the parties, right? And what we really want is to have free agreement from the two parties. Now that often takes the form of an offer being made by one of the parties and that offer being accepted by the other party. The offer is an expression of willingness by one party to enter into a contract on the verbal or written terms as stated. And it's a promise to do or not to do something in return. And then acceptance is an unmistakable statement with words, can be via conduct, you can accept a contract by conduct, or in writing by the other party to respond and accept the offer. So we've got offer and acceptance. We talked about jurisprudence and the idea that some rules and laws are positivistic. They're positivism. They are just positive rules. They are a set of rules. And then we also talked about natural law theories of inherent rules or ideas of justice. Think human rights law, the right to life. These would be classified as natural laws. Think natural and morals, whereas positivism is around you can make any rule you like. Contract law is quite a positivistic area of law in that you can generate rules however you like. So think about stevedores when you load goods from a ship at the docks and you pick up a shipping container and you're loading it onto the dock. At some point, ownership will shift from the transporter to the person receiving. And is it where the crane is in the middle? Is it when it leaves the ship? Or is it when the container is put down on the dock? So you can decide that wherever you like. You can make a positivistic rule and say, no, in the law of contract, shipping contracts, where ownership will pass from the seller to the purchaser at this point when the container hits the dock. All right, and that's really important to know when ownership moves because of risk. Who's insuring the goods at that time? So who's owning those goods when they're in the air on the crane on their way from the ship to the dock? So you can make rules in this area of law. Now, most common law jurisdictions have settled, because it's hundreds of years old, on certain common law rules. So, for example, a common misapprehension is, a contract's got to be in writing or it's not binding. Well, that's not true at all. However, there are certain contracts that must be in writing in order to be valid and enforceable. And the classic one is land. And the transfer of land, the sale of land, or the granting of rights over land, such as a tenancy, for example. So you can just, and that's because it's serious, I suppose, and the gravity of the matter, whereas you can buy and sell a car verbally. Absolutely. Now, in practice, in real terms, you want it in writing, as in any agreement, if you can, if it's important, so that you've got evidence, so that if it doesn't go well, you've got some evidence to prove the facts as you're asserting. However, if you're entering into a common contract, like getting on a bus and paying the pound fare, you wouldn't probably bother getting that in writing, although back in the day they used to give you a ticket. So you had it in writing, you had a document. But now, micro contracts, small contracts, you just enter into verbally and just by conduct, by handing over the pound to the bus driver. Their offer is the door opening and you stepping in, you accepting it. The offer to transport you on their bus, you accept that by paying your money. And you'll see that's called consideration. We'll get to that. So what we're after is free agreement from two or one or more parties to enter into a mutual promise. Okay, it's also known as the law of promises, because the promisor offers to do something in return for something else. So we're both agreeing to do something. That's the fundamental nexus of a contract. And so this is the law of agreement. You've made an agreement. So Carlyle and Carbolic smoke ball is a classic case around what's actually an offer and when is it accepted. So we're looking for agreement, free agreement, because essentially that's what this law is governing. Now, in order to be binding, there needs to be some consideration. And this is the price one party pays for the promise of the other party. So I can make an offer, but you need to do something in order to become the other part to accept that offer. So you can have unilateral contracts and you can have bilateral contracts. So unilateral contracts are an offer to the world, and they're just from one party. So think of a lost dog poster. Can you find my dog? I'll give you $100 or pounds reward. Well, that's an offer to the world at large. And no one's really, you don't have to go find that dog, do you? You don't have to accept that offer. Whereas if you go and found that dog and presented it, well, then you've acted and all of a sudden you've got a contract. So in order to be binding, we need consideration. And on the bus transport example, it would be the paying of the pound or the dollar. It doesn't need to be money, but it usually is. But it needs to be the exchange of something of value. And this is why you have peppercorn rents. So they had to give a peppercorn in order for consideration for the contract to be valid and lawfully binding. So it could be assigning a number of shares, or it could be something as simple as agreeing to pay for monthly services with a loaf of freshly baked bread. So once you've agreed, then you need to be, in order for it to be binding, we're looking for some consideration, something to move from one of the parties to the other. Now, in order for it to be a lawful binding contract, we need intention to create legal relations. So two brothers bouncing on a trampoline, and one says, "Oh, I'll give you £1,000 if you go and get me a can of Coke." There's no intention to create legal relations there, so that can't be a binding contract, okay? That would be mere puffery. And there's some cases around, I think Pepsi, if you collected tokens, you could get a jet plane. Well, obviously no one's getting a jet plane from cans of Pepsi, so that was mere puff. So we need an intention to create legal relations. This is not usually an issue where one party pays the other valuable consideration. because that is the evidence to be bound. That is the evidence to create legal relations. I give the bus driver the pound, we're on. I've paid some money. You pay a deposit on some goods, you're on. You've paid consideration and you've entered into a contract. And so if there's no intention to create legal relations, you won't have a binding contract. Another rule is about capacity of the parties. And normally, young people under the age of 18 do not have capacity to enter into contracts. There are some exceptions around necessities, often cases from boarding schools and minors getting clothes and food, etc. So there are some exceptions, but on the whole, there is a floor at the age of majority or 18. But likewise, capacity, think about people's mental capacity to fully understand the consequences of their actions. They would not have the competency to enter into a binding agreement. So if they're not capable of understanding the nature of the transaction and the other party knew of that mental incapacity at the relevant time, then you may be able to void the contract due to an issue of capacity. There are some formalities of contract. As I said, on the whole, a verbal contract is legally binding. And that's right. And that should be if you imagine if you had to write a contract out every time you wanted to engage in a service or buy goods, it would take forever. So we have allowed most contracts to be established verbally, with the exception, as I said earlier, of land, and in some jurisdictions, the offering of credit. So credit licensing, credit acts of governments and legislation would mandate that certain credit facilities or agreements are evidenced in writing. This is to reduce fraudulent claims and to provide, again, more certainty and quite serious issues around contract of credit and land, obviously, because they represent significant assets and have the ability to bankrupt people. So there are some other prohibitions, such as if a contract was made to conduct an illegal purpose or to commit a crime, that would be void due to being contrary to public policy. So some contracts would be unenforceable, even if they had evidence to create legal relations. There was some mutual agreement found, there was some consideration. You can still void a contract if it's contrary to public policy. So let's have a think about most contracts are performed without any problem, and both parties honour their obligations. So you could get a house built, or a car is sold, or an item of clothing is purchased. However, the relationship can go wrong and the terms of the contract may not be honoured, and one party, whoever's disappointed, will want the contract enforced or performed, and if it can't be performed, well, then they're going to want compensation, which is designed to put you in a position you would have been had the contract been performed. So if it's a legally binding, lawfully authorised contract, or legally binding, then the aggrieved party can go to court and ask for relief, a remedy, and an outcome that honours the mutual agreement that was made. Courts view contracts objectively, so they'll take a view of what the reasonable person would have done. They try and put themselves in the position of the parties at the formation of the contract, and they try and get inside the head of those parties and try and work out what the intention was at the time the contract was made. All right, because you're trying to give effect to the intention of the parties. Again, because it's a positivist area of law, there are some rules set around what can be brought in and what can be excluded. There's your classic four corners rule, where only the things in the four corners of the document can be incorporated. However, there are some exceptions, and if there were some negotiations leading up to the contract, the prudent party would ensure that they were inserted into the document. But if you can argue that you were induced into that document by representations made prior, well, then that may well be taken into account. But on the whole, the parole evidence rule says it's either in or it's out. That's what you've signed. That's what you're going to be bound by, both parties. So it's really important, therefore, that all negotiated terms find their way into that final document. And if you were relying on pre-contractual negotiations, get them in, put them in the contract, and for the avoidance of doubt, it's reduced to writing. Everyone can see what was actually agreed. So the court's seeking to find what the intention of the parties is behind the contract, and that's a fallacy, but it's possible. You can look at trade usage, practice. What's the common terms in that industry, etc., to try and impute into the mind of each contract party at the time the contract was agreed to. So the court would assess all the evidence. They'd apply the law of contract, which I said are a set of principles around some certain agreed or landed on positions, and then decide what the outcome of the parties should be. And then we'll make an enforceable decision against one party. So it can say, well, no, you will perform the rest of the contract. That's called specific performance. Now, traditionally, UK courts and courts around the world are a bit loath to order specific performance, because if you don't do it, well, then you've still left the aggrieved party unsatisfied, and all they can do is come back to court, and we'd be clogging up the courts, and the wheels of justice, which turn oh so slowly, would go even slower. So usually they prefer a remedy of damages over a remedy of specific performance, because it's easier just to reduce it to money, and then that's the end of the matter once and for all. However, if it's a unique contract, such as for a unique work of art or goods that are not easily replaceable, or a unique skill of an individual perhaps, then the court may order specific performance, because money's really not going to compensate. If the essence of the deal was to secure that specific performance of that dancer or that singer or that work of art or that rare Porsche, well, then specific performance may be the appropriate remedy. Usually, though, monetary compensation to put the party in the position they would have been in had the contract been performed, that'll be the preferred remedy, and that's called damages. Now, because we're in the common law system, we have the notion of law and we have equitable principles, which is around fairness. One problem with contract law, and we touched on it earlier, is there's a presumption that it's a level playing field, and that when these negotiations are on foot and the terms and the agreement is being meshed out, that either party can freely bargain. Now, as I've said, the world's not really like that, and most people don't either understand what their contractual rights are or how to advocate for their protection. So the law of contract is aware of this, and it's got a number of tools. We've got common law principles are available to even up the playing field. We've also got codified principles into statute, as I talked to earlier, around the statutory guarantees, which put minimum floors in the contract. It inserts implied terms into the contract. So, some big things to think about. We've got relationships of undue influence and advantage. If it can be shown to a court that one party exerts undue influence over another to enter into the contractual agreement, the court can set the contract aside. So think about even within a husband and wife where there's pressure to move some assets or move move the title from someone's name to another, and they threaten, then that could be set aside for undue influence. The influence can be actual, such as a violent relationship, or a presumed, where the very nature of the relationship means there's a power imbalance, such as between a doctor and a patient, a parent and a child, and even a lawyer and their client. They're called fiduciary relationships, where there's an inherent imbalance of power, and wherever there is, that would be seen as undue influence or an unfair advantage from one party over the other. And where this can be established, the onus is on the stronger party to prove that the weaker party did enter into the contract freely and with their full consent. Why? Because we want free agreement. This is the law of free agreement. The law of mutual obligations. Well, if it's not free, it's not mutual. All right. So if you can understand that the cornerstone of this is to freedom of contract, let the parties do what they want. But if they do it, then we have a binding, valid, legal contract. The courts will enforce that. So regardless as to the quality of the bargain, not interested. You're allowed to make a bad deal. But the deal, if it's lawful, will be enforceable. All right, and that's the certainty that the law of contract will provide society and say for the wheels of commerce. What about people engaging in unconscionable conduct against a disadvantaged party, where a stronger party knows and exploits a special disability of the weaker party? The contract can be avoided on the grounds it would be unconscionable. So special disability could be age, literacy, language, mental incapacity, even drunkenness. So a key case is Commercial Bank of Australia and Amadio. A big issue in contract law is misrepresentation. So this is about information or misleading and deceptive conduct. Now, again, a lot of statutory guarantees will embed misleading and deceptive conduct into legislation, where contracts can be set aside if there has been misleading and deceptive conduct on the part of one party. Why? Well, because then it's not a mutual free agreement. Someone's been tricked. And again, that goes to the underlying principle of enforcing contracts that were freely entered into. So as we have the offer, often before the acceptance there's a counter offer, there could be another counter offer, and parties would propose terms of the deal until the terms become acceptable to them, and that's when they've made the deal. During the time of negotiation, some parties may make a false statement about an important fact about the deal, which causes the other party to enter into it on that misunderstanding or misrepresentation. So if they've misrepresented a key facet of the deal, they shouldn't be able to take advantage of that. So misrepresentations, you will be able to get the contract void and set aside. All right, so I've got on this screen here the UK Contract Applicable Law Act 1990, which talks to some of these implied terms. In the UK, there's also UCTA, the Unfair Contract Terms Act, which again avoids and outlaws, if you like, certain conduct in and around the law of contract. All right, so we've got certainty, we've got the wheels of commerce turning, and we want to regulate those relationships. Contracts are everywhere, not just big deals, but we often enter into them every day. And the law can imply certain minimum standards and terms into those contracts in order to set a floor so that we're not having to re-prosecute and renegotiate basic terms every time we enter into a contract. There are formalities around a contract. You want capacity to be able to enter into it. Courts will try and find out what is the intention of the parties at the time of the contract. There are presumptions around capacity, and you need to be of a certain age and in a certain state. And if you contracted with someone incapacitated, either temporarily through drink or drugs or and temporary illness, then again the court may well be able to set that aside. And that's right, because we're trying to enforce the law of free agreements. We don't really need everything to be in writing. There needs to be an offer, a genuine offer. And in contract law, there's this other thing called an invitation to treat, which confuses first-year law subjects. So an invitation to treat is almost a pre-offer. And the difference is an invitation to treat, it's trying to get a customer to submit an offer, whereas the offer is an actual invitation communicated by one of the party and if it's accepted, we've got a legally binding contract. However, an invitation to treat is an invitation to enter into negotiations with an intention to get to an offer. So, example of an invitation to treat, auction. So, request for bids. Here we got an item, any bid. So at that point, there's been no offer made. It's an invitation to treat. What about displaying of goods on a shelf? It might have a price tag, but at that point, it's still an invitation to treat. Or an invitation for tenders, often governments putting out tenders for work. A general advertisement of goods, a company prospectus for shares. These would all be invitations to treat. The importance of contract law cannot be overstated. If we didn't have the law of mutual obligations, trade, and if you go the step under, it's mutual trust, it would be chaos. And we'd end up with, well, people wouldn't bother to do things of economic progress, manufacturing, everything would grind to a halt. So contract law, very important to set a floor on mutual obligations. It gives governments opportunities to come in over the top and add specific standards to the trading floor, to the marketplace, and thereby generate a standard of a marketplace. You can have specialised areas. Think of international shipping and international trade. There are things called Incoterms, which are, think of Incoterms as pre-arranged or pre-agreed definitions of terms, and they're numbered. So you and I can create a contract for the delivery of goods, and we can just select pre-numbered Incoterms and incorporate those into our document, into our contract. Amazing. It should happen in many more industries. I know in banking there are contractual complications about meanings of terms. So it's really important to get your definitions stated in the contract from the beginning so that both parties know what the actual terms are relating to. As I said, in banking, you can have facilities, overdrafts. If they have different meanings to different institutions, it's very hard to contract. So, as I said, they've avoided that in the land of international shipping and the transfer of goods and ownership and property, and by the establishing of these things called Incoterms, whereby you can contract with certainty, knowing that both parties have a common agreement on the definition of the terms. So it needs to be, an offer needs to be accepted to be binding. If you went into a shop and there was a poster that said lemons for a pound each, they're not obliged to sell you a lemon at £1. You could say, oh, I'll have 100 of them, and they say, oh, we haven't got 100. They're not in breach of contract. That's merely an invitation to treat. Contracts are around us everywhere. And as I said, it's a positivistic area of law. So governments are able to change and amend terms of contracts at will. International law may have some effect. European law, but obviously as Brexit unfolds and the unentwining of European legislation and directives over the UK legal landscape, we shall see how untangled British law becomes from European Union law. But in the interests of free commerce and trade across Europe, you would imagine that Britain would retain a lot of those standards that have been established during the evolution of the European Union since the formation of the single market in 1991. All right. Contract 101. I think we'll leave it there. Thanks very much.